Hospital may be held liable in damages for the negligence of its medical staff. The hospital may exclude substandard and unqualified practitioners from their staff. The hospital will be held liable if it knew or through diligent inquiry should have known that a physician is incompetent. Frequently, the applicant physician is a new graduate, recently licensed, and without a track record of clinical practice. Then there are applicants who are experienced physicians moving from other countries or other states, and then non-board certified practitioners with varying degrees of expertise who have practiced their specialty for many years. The most recent decisions in federal and state courts tend to give the benefit of doubt to the hospitals if and when it can be established that a good faith effort was made to evaluate the qualifications of a new applicant or revoke privileges. Committee actions must also be reasonable, and members must act without malice and no showing of racial or religious discrimination. And the hospital, whether private or public, must at all times follow its bylaws. The courts are in essence demanding from hospitals fundamental fairness under all the circumstances, both in regards to substantive and procedural matters. The physician's best defense is the showing of a high standard of professional patient care and ethical conduct. It is well known that a physician who is denied access to a hospital may be severely hampered in his ability to practice his or her profession. If a physician's privileges have been refused or denied arbitrarily, he or she is entitled to judicial relief, and the degree of help that the physician may receive from the courts will depend largely on the facts of each case and whether the hospital is a private or a public institution, or in some cases, as the courts have held, a quasi-public institution. With regard to public hospitals, the majority of our courts have held that licensed practitioners may not be excluded and denied staff privileges by unreasonable or discriminatory methods. In the case of the public hospitals, the courts have little hesitancy to intervene and substitute their own judgment for that of the hospital administration. But when it comes to a private hospital, the courts are more hesitant to intervene unless there is a clear violation of constitutional safeguards. With respect to quasi-public hospitals, these fall somewhere in between the public and the private hospital, and here the courts are less likely to intervene than in the cases of the public hospitals. On the other hand, courts are more ready to protect the individual's right in the quasi-public than in the private hospital if there is some state involvement and a nexus is shown in aiding or approving the complained of activity. What in the eyes of the court are the grounds for exclusion of physicians from hospital medical staff? Clearly, incompetence or misconduct of the physician can be a valid ground for denial or revocation of medical staff privileges in both public, quasi-public, and private hospitals. The following are some examples where the courts upheld denials of privileges or suspension of the hospital staff physicians. In the Iowa case of Kelling versus Board of Trustees, the court upheld the suspension of a physician for intentionally making deceptive or misleading entries on the patient's chart, falsely explaining professional conduct, and inadequate care of patients who are critically ill. In Anderson versus Board of Trustees, a Michigan case, screaming and swearing, publicly swearing at other staff members, and surreptitiously examining hospital charts of other doctors, and quarreling with hospital guests, were grounds for suspension. In Ponca City Hospital versus James W. Murphy, MD, an Oklahoma case, it upheld the suspension of a physician for disruptive activities and difficulties with working with radiology personnel, even after the physician held privileges for 20 years. In an Oregon case, Hoffaker versus Bailey, a physician throwing a scrub brush at a nurse, a physician's unwarranted interruption of a training session, verbal abuse of hospital employees have also been found to be sufficient personality conflicts which were reasonably related to the quality of patient care and therefore legitimate grounds for revoking privileges. The injection of religious beliefs and practices into medicine has frequently arisen in cases involving abortions. In Watkins versus Mercy Medical Center, an Iowa case, where a physician's privileges were revoked for performing sterilization and abortion, the court found that the hospital had a right to adhere to its own religious beliefs and could not be forced to make its facilities available for procedures it found repugnant and prohibited by its religious beliefs. Hospital staff privileges may also be denied for failure or refusal to comply with hospital rules and regulations. For example, a rule requiring a complete medical history on a patient was upheld, but a rule requiring any doctor to give professional assistance to any other doctor in a hospital was found by the court to be unconstitutional interference with the person's liberty of the physician. That was in the Arizona case, Finley versus Board of Supervisors. Not only failure to complete medical history, but also other lesser inadequacies in the chart were found to be reasonable grounds for suspension or revocation of staff privileges. Let us now turn to the other side of the coin. What are the hospital's obligations to the medical staff? Courts have held that hospitals have a fiduciary obligation to refrain from denying or revoking privileges. The courts will not tolerate arbitrary or capricious action or unfair procedure. The injured physician must always be notified of the reasons for the proposed action and be given an opportunity to defend himself or herself. That was the holding in the case of Pinsker versus Pacific Society of Orthodontists. In dealing with quasi-public hospitals, some courts, as in the Washington case of Rayo versus Overon General Hospital, have held that in the area of determining privileges, they are subject to the same responsibility as public hospitals. The Oklahoma Supreme Court held in the case of Ponca City versus Murphy that the mere fact that a hospital is partially financed with federal, state, and state funds does not automatically make it a state institution or a quasi-public hospital. The court held that in the absence of showing of a causal relationship between the state's activity causing injury and the claim of discrimination because of race, sex, or age, the court will not intervene. The Oklahoma court adopted a three-pronged test for determining the existence of state action. This test provides, in order for a private hospital to be subject to the procedural requirements of the 14th Amendment, as well as other amendments of the U.S. Constitution, it must have shown that, 1, the state's involvement in the private institution is significant, and the state must be involved in the activity that caused the injury, that is, a nexus must exist, and 3, the state's involvement must aid, encourage, or control the activity. In Ponca City, the Supreme Court of Oklahoma adopted the definition of Shulman versus Washington Hospital Center, which stated that a public hospital is one owned, maintained, and operated by a governmental unit, such as a municipality or a county, and supported by government funds. In contrast, the private hospital is one that is maintained and operated by a corporation or an individual without participation on the part of any governmental agency in its control. Court held, hospital achieves quasi-public status when there is some government right to supervise the internal affairs of the hospital, and some of its acts may be classified as state action. Merely receiving state funds or financial assistance or grants or contributions does not make a hospital a quasi-public institution. Let's now turn to due process and hospital medical staff physicians. In general, the minimum requirements of due process in resolving questions of hospital staff privileges require: 1. Written notice, spelling out the specific reason for denial of privileges. 2. An opportunity for a timely hearing after such notice. 3. An opportunity for the physician to produce evidence and or witnesses to refute the allegations. 4. A requirement that the hearing and adjudicating process be impartial. 5. A finding by the reviewers based on substantial, credible evidence. 6. A written notice to the physician of the recommended decision, including the reasons for the decision. And 7. An opportunity to appeal. Unlike court proceedings, during hospital committee hearings, the physician does not necessarily have a right to confront and cross-examine witnesses. Courts have held that cross-examination of those who provide adverse information is not an essential ingredient of the administrative process. During such a hearing, the physician must be permitted to present his or her own witnesses and any evidence that could be reasonably refuting the charges. And the courts have also held that evidence must be substantial and credible, as in the case of Anton versus San Antonio Community Hospital. Decisions by the community must also be based solely on evidence produced at the hearing and not on information obtained privately or confidentially by committee members outside the hearing. Hospital rules may allow the physician to be represented by an attorney during the hearing, but this is not mandatory. In some states, for example in New Jersey, it is by statute. However, if the hospital attorney is present, it can be argued that the physician also could be allowed to have an attorney represent him. That was the case in Garrow versus Elizabeth General Hospital. Courts have also held that due process requires a prompt hearing, and any undue delays will be considered prejudicial. A delay of a few days, 5 days, was described by one court as insignificant, since the doctor was not damaged or prejudiced by the minor technical violation of the law. Appeals from the various committees are made to the Hospital Executive Committee or Board of Trustees. Usually such review is restricted to determination of the bylaws that were followed, and there should be substantial evidence to support that. As long as such an appellant process exists, the courts hold that the administrative remedies, for example, appeal to the board, should be exhausted before a lawsuit is filed. Such courts include Garrow versus Elizabeth General Hospital, Brickman versus Board of Directors of West Jefferson Hospital, and Schulman versus Washington Hospital Center. Historically, the requirements for hospital privileges were primarily limited to healthcare providers holding MD degrees. However, with increasing specialization in medicine, and because of fear of malpractice litigation, many larger hospitals are increasingly limiting privileges to board-certified specialists, while allowing certain non-board certified specialists to retain privileges under the so-called grandfather clause. In recent years, there has also been a concerted effort by other healthcare providers to obtain privileges, either full or limited, for a variety of professions and para-professions, such as podiatrists, chiropractors, optometrists, and of course osteopaths. The ability of these healthcare providers to obtain privileges varies in different states and may depend on the statutory definition of physician in that state. For example, in Bruce versus Darnell, the Oklahoma Supreme Court held that chiropractors were not physicians under Oklahoma statutes and were therefore properly excluded from hospitals. In another decision, the Jolly case, the Missouri court held that osteopaths are physicians under the statutes and exclusion from a private hospital was deemed improper. Generally, exclusion of osteopaths and podiatrists has been accomplished under a rule that hospital medical staff privileges will be granted only to graduates of medical school approved by the American Medical Association. This led to considerable litigation which held that such requirements were capricious and arbitrary and violative of the constitutional rights of healthcare providers. As a result, the barriers against osteopaths were lowered, while many osteopathic schools have upgraded their curricula to a virtual equivalent to medical schools. The American Medical Association has dropped its efforts to avoid entering osteopaths in a hospital. Challenges have also been made on antitrust theories, where the hospital is the only one in the area, and the osteopaths were precluded from practicing their professions. Now, what are the remedies that are available to physicians? A physician who is injured by a denial of privileges on arbitrary and capricious grounds has a plethora of legal remedies available to him or her. These include suits in contract, tort, for example, defamation, interference with the practice of the profession, or antitrust. The most common is injunctive relief, which may be tailored to the circumstance of the case. This is one of the speediest remedies available. The hospital can be immediately ordered to reinstate the physician or enjoined from denying privileges, and all hearings and procedures of investigating the doctor must be conducted while the physician remains on the staff. However, in order to obtain such injunctive relief, there must be, first, a very strong showing that the physician would be irreparably damaged by an immediate suspension or denial of privileges, and two, there is a strong likelihood that he or she will prevail in future litigation. In some cases, especially in cases of public hospitals, the state agency may be ordered by a writ of mandamus to compel it to admit a physician to the staff. Another remedy frequently used by physicians whose privileges have been revoked are suits for damages. They may be in contract, either express or implied, and or may be in the bylaws. Also, tort suits may include both actual or punitive damages if arbitrary and outrageous conduct on the part of the hospital or committee members could be demonstrated. One of the more frequently used legal remedies to obtain redress is the theory of a civil conspiracy to injure the plaintiff professionally and deny or suspend privileges. The existence of a conspiracy, if it can be established, is one of the most potent weapons the physician has in defending himself or herself against arbitrary or capricious denial of privileges, because he or she can collect both actual and punitive damages. A significant decision dealing with civil conspiracy to injure a physician in the lawful conduct of practice of his profession is the case of Nashville Memorial Hospital. There the court held that it is not necessary to expressly allege malice in an action for conspiracy as long as it is alleged that the damages were done intentionally and without legal justification. Physicians who have been denied privileges at the hospital often sue on the basis of federal antitrust laws. Specifically, Section 1 of the Sherman Act prohibits any contract, combination, or conspiracy in restraint of trade. In addition, Section 2 of the Sherman Act prohibits monopolization or attempts to monopolize a relevant area of commerce. Suits under this section do not require a conspiracy or a concerted effort by two or more individuals and can be directed at a single entity, a hospital, or an individual. The punitive measure of damages in private antitrust lawsuits is the possibility of treble damages. Another federal antitrust weapon is Section 5 of the Federal Trade Commission Act, which prohibits unfair methods of competition in commerce. Unlike suits under the Sherman Act, which can be brought by individuals, enforcement of the Federal Trade Commission Act is left exclusively to the Department of Justice or the Federal Trade Commission. Denial of privileges to a physician may give rise to antitrust liability by the hospital if the physician can prove that it is the result of conspiracy and an anti-competitive restraint on trade. These types of lawsuits are common where hospitals receive out-of-state patients or where there are exclusive service contracts where one doctor or a group of doctors who provide special services for the hospital. Arguments about availability of physicians for certain type of work and the need for close working relationship have helped certain hospitals to overcome antitrust allegations by the excluded physicians. In antitrust litigation, the courts have occasionally pierced the veil of confidentiality and immunity and allowed access to medical review proceedings. In conclusion, we must remember that a hospital may be held liable in damages for the negligence of its medical staff, and the hospital may exclude substandard or unqualified practitioners from their staff. We have learned that the courts are demanding from hospitals fundamental fairness under all the facts and circumstances, both in regard to substantive and procedural matters. The physician's best defense is a showing of a high standard of patient care and ethical conduct. Incompetence or misconduct of physician can be a valid ground for denial or revocation of medical staff privileges. Hospitals have a fiduciary obligation to refrain from arbitrarily denying or revoking privileges. And the courts have set minimum requirements of due process in resolving questions dealing with hospital staff privileges. And finally, we have learned that the physician who is injured by denial of privileges or by arbitrary or capricious removal from the staff has a plethora of legal remedies available to him or her, including suits in contract, torts, and antitrust.